To this now, Sakeliga has won its bid to declare the 2017 preferential procurement regulations invalid. The ConCourt this week ruled in favour of the organisation, stating that then Finance Minister Pravin Gordhan acted beyond his scope when he brought the regulations. They resulted in companies that did not meet BEE requirements being automatically disqualified from applying for state tenders. Let's discuss this further with Sakeliga CEO Piet le Roux. We'll be joined by Kganki Matabane, that's CEO of the Black Business Council, as well as Pieter Steyn from Werksmen Attorneys for reaction to this particular judgment. Good afternoon, gentlemen, and thank you very much for your time. This is a very important judgment on whether preferential procurement legislation, in particular that of pre-qualification criteria, is permissible as per the Constitution. Now, Kganki, perhaps just to start with you, I read your statement. You are clearly very disappointed, aggrieved even, as BBC. Just unpack the issues that you have with that judgment.
Good evening, Mfundo and the panelists, as well as the viewers at home. The ruling for us was not about economic transformation. It was just about the administrative powers of what is called executive authority, which is the Minister of Finance. So as far as we were concerned, this does not necessarily affect broad-based black economic empowerment, because Section 2 of the PPFA and also Section 10 of the Broad-Based Black Economic Empowerment Act mandates organs of state and public entities to develop procurement policies that's basically applying relevant codes of practice as per the Act in determining qualification criteria, for example, when they issue licenses, concessions, and other authorizations. So the organs of state and the public entities, which are SOCs, they're supposed to develop and implement preferential procurement policies and determine qualifying criteria. So as far as we are concerned, the issue is not about BBC, Broad-Based Economic Empowerment Act.
Mm-hmm. But then if we speak
disappointed
here...
About,
you can continue?
Yeah, I'm saying our disappointment, sorry for them. Our disappointment is that those who are anti-transformation, they are trying to create a perception that transformation is late. Which is not
but all of us, if we read that judgment in its entirety, we would know that it's not necessarily the transformation or anti-transformation question or debate here, but rather about the scope of the finance minister, whether he acted within the confines of the law or not. If we're talking about the regulations 3B, 2 as well as 9, that if we look here, if one speaks of the power of the minister, I'm sure everybody saw that when they were speaking about Section 5, we had a minority judgment and a majority judgment, and in both it seemed they argued about whether the minister actually was well within his rights when promulgating those regulations. But then that, one would say, Kganki, is clearly a problem of an administrative or legal technicality that was being actually challenged here in court, would you say?
Yeah, I think that is a administrative issue, and you're right, it's a legal issue as well. But I think those who were reporting on the matter, they created an impression that it was a bad day for BEE, BEE is lost, BEE is gone, and we were saying black economic empowerment will only come to an end when the ownership and the control of the economy reflects the demographics. So if white people are 5%, they should only control and own 5%, and that's when we can talk about whether BEE must come to an end or not.
Mm-hmm. Now, before we go to Pieter, who is in fact our legal practitioner today, let's talk to Piet now. Piet, to bring you in here, do you feel vindicated? Talk to me about what was exactly at the heart of this case. What was problematic for you when we talk about the Procurement Act itself and then the regulations?
This judgment was very important for two things. First, for the separation of powers between the executive and the executive and the legislature. So the executive power, Mr. Gordhan in this case, stepped outside the bounds set to him by the legislature. And therefore, it's a very important judgment. It's not simply a technicality. Minister Gordhan acted as if he was legislating. And if we allow that to stand, and if we allow that to become a habit, we actually undermine the separation of powers that the Constitution envisages, and it becomes dictated by fiat through ministers instead of lawmaking in legislating in Parliament. So it's not a technical case, it's a crucial case for the separation of powers. Mm-hmm. But that's not the only thing. What was before the court was not the question of BE itself. Sakeliga as opposed to BE, we think it's a harmful policy. We're not alone in this. Across the board, there is opposition and concern about BE. So we are very glad that this is also very important for BE, because it rolls back the procurement aspects of BE, which is only one of the tentacles of BE. It rolls back one aspect of that from the 2017 regulations back to the 2011 regulations, and in fact back to the limits set by the Act that was made by Parliament in 2000. So it's important for both BE and for the separation of powers. The case before the court was not to judge on BE, but we are very mindful, and we were purposefully brought this case not only to make sure that there is a separation of powers, but with a full knowledge that if we succeed, it will also roll back a very harmful extension of BE, because it made the pool from which tenders could be gained, from which the state could procure services and goods in the benefit of the public. It made that pool much smaller to the harm of the public.
Because of that pre-qualification criteria. Pieter, then to bring you in here, we've got the minority judgment. When we read that judgment, we start with that minority by Judge Mhlanhla, then we go on to Madlanga's. These two are in contrast when we speak about the scope. You've got one Judge Mhlanhla here stating that, in fact, he believes the minister has the right and the authority to promulgate. And then we had Madlanga going on to state that, no, he didn't. He didn't act within the scope if we look at some of these regulations that are impugned.
Yes, I think, as the practical consequences of this decision is actually very important. Because what the Supreme Court of Appeal found in September 2020, they set aside all the preferential procurement policy regulations and declared pre-qualification criteria as invalid. So that has huge implications for any state tender since that period, which has applied pre-qualification criteria in practice. What the Supreme Court of Appeal did was they suspended that order of invalidity for 12 months. The 12 months has expired. So the effect of this Constitutional Court judgment is effectively that there are no regulations dealing with state procurement, which causes a lot of uncertainty. Now, getting back to the minority and majority, it was quite a close call. I mean, 4 judges in the minority supporting the minority judgment, 5 judges for the majority. And if you read the judgment, the focus really is on the wording of the section of the Act giving the minister the right or the power to make regulations. And the wording is that he can make regulations in any matter necessary or expedient to achieve the objects of the Act. And you'll see that it's a great legal debate as to what does the words necessary or expedient
really mean.
Yeah. So the majority and the approach, in fact, was the minority judgment seemed to interpret that wording as you look at the Constitution. In the Constitution, it's quite clear from the Constitution that preferential procurement in favour of historically disadvantaged persons and groups is constitutionally permitted. Whereas the majority judgment said, well, and maybe I don't want to get too legalistic here, but the majority judgment said, no, you must actually interpret necessary or expedient having regard to the Act itself, because it's the achievement of the Act. And the Act,
I just actually want to interject here. Actually, it seemed to be a concession of Mhlanhla in his minority judgment, where he goes on to state that, in fact, there are deficiencies. Because if we're talking about the Procurement Act itself, regulations give life to the Act. But the Act is the one that is most senior, and then you would have the other being more secondary. But now, if you have some misalignment between the regulations and the Act, it's problematic. Because Section 2 was talking about the point system when we look at the Act. And now you have pre-qualification when you look at the regulations. What did you make of that? Apologies, gentlemen. We actually have to go to a break. We'll touch base with you, Pieter, just after this.